Hello, everyone. This is Steve Wilkes at the Wagner Law Group. Thank you for your patience. We had a little technical difficulty. I don't think it was North Korea trying to poach into this webinar, but you never know. Again, thanks for your patience. Today, we're going to talk about performance advertising for those of you that are interested from our advisory base of clients. Why is this important? Why are we talking about it? We'll give a little overview on advertising generally. We'll talk some of the specifics on performance advertising, a little bit about some of the record-keeping requirements that go with it, and enforcement activity recently. Okay, here we go. Welcome again. Why are we here today? As many of you know, our practice is very focused on the ERISA investment pension aspects of the retirement world, but we also, hand in glove with that, deal with the related securities laws, Advisors Act, FINRA, so on. And we often get questions about the Advisors Act implications of certain practices, procedures, product development, sales activities, and so on. So performance advertising has come up several times recently, and that's why we put it on the agenda. I think what I'm seeing is, number one, people are always interested in attracting assets, and one of the ways you do that is to exercise your bragging rights and talk about what you've accomplished. We also see that on our retail platform, where people are moving toward putting together customized portfolios and managing them with some discretion as compared to simply on a non-discretionary basis putting out an investment lineup. You know, there may be certain reporting obligations with clients in terms of performance. Methodology is a big piece of that. I think we see some distinctions evolving on, you know, retail or institutional investors and the role that performance reporting plays on that and how that's handled. And clearly, we see it as a major area of concern from the securities side. We know that in 2015, both FINRA and the SEC, in their own way, have announced enforcement initiatives that touch very directly on the retirement world. And in one way or another, they'll be looking at performance advertising because it reflects on sales practices, internal compliance procedures, overall best interests of suitability for specific investors and what have you. So we think it's timely to talk about this today. Let me give a little bit of a quick overview just to kind of set the frame. I know I did a webinar back in the fall, I think, on advertising, but let me see if I can talk about it again a little bit and kind of set the frame before we go into performance advertising. The SEC has spent a lot of time in the world of advertising and you know, related issues, testimonials, and what have you, but today we're going to talk about performance advertising in particular. The regulatory regime for this comes under the Advisors Act, Section 206 and Rule 206-4-1. And the way that section works is that it makes it unlawful for any advisor to use the mail or, you know, interstate commerce to employ any method or device, you know, which deceives or manipulates a client in any way, or to engage in any kind of transaction or practice which operates as a fraud or a deceit. And this applies to all investment advisors, by the way, even if you're exempt from registration under the Act. A person, by the way, you can violate this provision even if you don't have volition. In other words, it can apply even if the practice is unintentional. Just, it's very similar to the per se nature of certain ERISA prohibited transactions. Then the Advisors Act goes on to provide, you know, special rulemaking, you know, that they can do certain things. That's where the advertising rule comes from, you know, 206-4, where they talk about advertising. So under the advertising rule, there were really 4 specific prohibitions and then a general kind of catch-all provision about advertising per se. I want to point out to you, as many of you probably already know, that you know, advertising is defined very, very broadly. You know, any written communication addressed to more than one person, announcements, in publications, radio, television, which offers advice about securities. It'll be interesting as an aside, I would say, to see how the continuing attention from the SEC and FINRA on social media and the use of technology, how that might ultimately continue to refine this rule. The staff, by the way, doesn't view mutual funds, investment company advertisements for purposes of this rule, as long as they're not directed to existing or prospective advisory clients. So there's some exceptions there. So aside from these exceptions, the SEC is typically given a very broad interpretation to what constitutes an advertisement. And the courts have done the same in various cases. And the SEC has also done it with their no-action positions. It can be oral communications, things that are tailored, and again, as I mentioned, the certain things that are accepted under the mutual fund rules. In terms of specific prohibitions, as I said before, we have testimonials, past specific performance, certain graphs or charts, any statement that to the effect that a report or analysis or service is free, unless it really, really is. And then in addition to those things, they talk about, the SEC rule talks about prohibiting any advertisement that contains an untrue statement of a material fact or that is otherwise false or misleading. And false or misleading obviously involves facts and circumstances, can be very subjective, but we know from published guidance that the SEC will look at the following kind of factors to determine whether or not something is false or misleading. They consider the form and content of the advertisement. They consider the sophistication of the investor. They consider any implications or inferences that come out of the context of that particular communication. So they have a pretty wide arena to operate in. Anyway, that's a little bit on the background, on just advertising in general. Now let's talk about performance advertising. Interestingly, the SEC rule doesn't contain any express ban on the use of performance. They talk about performance, whether it's based on actual results or model portfolios, just in the context of whether advertisements are false or misleading. And that's how the SEC staff has always worked on it as well. The SEC has really evolved over the years. They used to view it initially as it's bad. That was their starting position, inherently unacceptable. But then over time, through the evolution of, requests for various no-action letters and what have you, they kind of came to a position where maybe with the right disclosures and the right explanations it would be okay, very much of a facts and circumstance test. And the famous guidance for this is published back in 1986 in a no-action letter that's referred to as Clover Capital. It's probably one of the most important letters the SEC ever put out. And they broke out different kinds of performance advertising to think about in those letters. First, they made some general statements with regard to model and actual performance. Whether it's model performance or actual performance, there's some universal truths that relate to both of those categories. And they said that the following practices would be misleading in either case of model or actual: failing to disclose the effect of material market or economic conditions on the results, failing, with certain exceptions, to reflect the deduction of advisory fees or brokerage fees or other commissions or other expenses. So this is what they really talk about when they mean net of fees. Failing to disclose whether and to what extent the results reflect the reinvestment of dividends. Just kind of suggesting or making claims about the potential for profit without, the yin and yang of also disclosing the possibility of loss. Comparing results to an index without disclosing all the material facts relevant to that comparison. and failing to disclose any material obligations or objectives, investment methods, or strategies that are used to obtain that particular performance as advertised. They would also, I think, say that whether it's model or actual, the failure to disclose that the advisor's clients had results that are different from what you see in the model, I think that would be something that would be, that would be critical as well. And then they talk about some things that are just relevant to model performance. And things they talk about in that case are the failure to disclose limitations that are kind of just inherent in the model, the failure to disclose material changes in the conditions, objectives, or investment strategies during the period portrayed, and how those changes might impact or affect, failing to disclose that maybe some of the securities or strategies reflected in the model don't relate, or only relate in a little bit or a tangential way to the services that are actually offered by that advisor, and failing to disclose, again, that the advisor's actual clients had results that were materially different from those portrayed in the model. And they also talk about, the actual performance results, and they say that it would be misleading if there was a failure to disclose results portraying, let me restate that. It would be misleading if there was a failure to disclose that the results portrayed related only to a select group of clients, and the basis on which that selection was made and the effect of this practice on the results portrayed. So it's a little bit of kind of cherry picking there in terms of your clients. And there's also some things that we know about specific performance that we've learned that's out there for us to consider. One of those is, I'll just call it the net of fees exception. And, we know that we're supposed to show for actual and model, we're supposed to show on a net basis after taking out advisory fees and brokerage. This has been around for a long time. It's probably good to reiterate here. Having said that, they've also, the SEC has kind of, made exceptions or relaxed the requirement a little bit. One is on the side-by-side gross and net of fees presentation. And here, the SEC has said that an advisor can advertise containing figures that have both gross and net of fees, as long as both sets of fees are presented in an equally prominent manner. There's a multi-manager type exception. I think it came in the same no-action letter, that an advisor that manages only a portion of an account can advertise performance figures relating only to that portion, so long as that performance is shown net of all the transaction costs and advisory fees or charges paid to the advisor and its affiliates. There's an exception for custodial fees that because an investment advisor performance might be presented without reflecting custodial fees paid to a bank, it's okay because it's the client usually is the one who selects and pays for that fee directly, so they feel that maybe that knowledge is imputed. There's also an exception for one-on-ones, and the staff has said that it wouldn't necessarily recommend enforcement if an advisor uses gross performance results one-on-one to certain kinds of clients, very wealthy prospective clients and consultants, provided that certain written disclosures are made, that they don't reflect the deduction of fees, that the return will be reduced by fees and other expenses, that the fees are described in the Form ADV, and so a couple of additional requirements. There's also some special rules that relate to just the deduction of model advisory fees. And again, going back to Clover, we're supposed to show things net of fees, and the SEC has clarified that this requirement means that net of fees means that performance must be presented net of all advisory fees actually charged to the customers and can't be presented net of a model fee. With certain grace period and some special rules around that. So I think another area about performance advertising, which is really important, is portability. We get a lot of questions on, well, I did this when I worked at company X, and I now employ the same strategy at company Y, or I have certain clients that have moved with me. And the portability of a performance raises a lot of issues. It's the ability of an advisor to cite as your own performance, the performance of a predecessor firm or firm at which the advisor's managers previously managed accounts. There's a lot of no action letters in this area, very facts and circumstance focused. We can talk about the performance of managers at a prior firm where, it's been okay with appropriate disclosure. As long as, I think the standard there was, as long as no person other than the manager played a significant part in the performance of accounts of those clients. There's also the question of, the performance of the manager's own personal accounts and whether that can be done. That's been a little tougher. But it's been allowed, provided that no individual other than the manager played a significant part in the performance of those accounts, and the results were not materially different, from the accounts of the advisors. Another common question we get is because of the consolidation of the industry, or firms, in effect buying, selling each other, merging into each other, the question of the performance of accounts that are purchased, from a predecessor firm. And the key letter there's a no action letter referred to as Great Lakes Advisors, and they wanted permission to use performance data of the predecessor. And they argued, of course, that with appropriate disclosure it would be okay. And the SEC said that it might not be misleading to use the data of a predecessor if no individual other than the successor's portfolio manager played a significant part in the performance of those accounts that were actually transferred over, and the performance of the predecessor accounts that weren't transferred didn't differ materially from the performance of the transferred accounts. So it's a very significant ruling. There's a lot of criteria in there and something to think about. There's some similar rulings on the performance of a joint venture partner, and I think that it's been allowed there. The Taurus advisory is the no action letter that matters. For that one, the request was granted, and they kind of reiterated the position taken in Great Lakes. And I think one thing that's happened also is that the test has kind of evolved and become a little more elegant, if you will. The no action letter that we know as Horizon Asset Management talks about the continuing primary role of portfolio managers that are responsible for ported performance, performance that's moving over. So it really stresses the ongoing role, the continuing role of that particular investment advisor. And it talks about situations where maybe there was a committee involved rather than just the input of one person. And I think at the end of the day, they come out with some standards, and they say that an advertisement for prior performance wouldn't in and of itself be misleading if the person who managed the account of the successor was primarily responsible for achieving the prior results. The accounts managed at the predecessor are very similar to the accounts currently under management at the successor, so that the results would appear to be relevant from one client base to the other. All the accounts are managed in a substantially similar manner, and the advertising is otherwise consistent with SEC positions on advertising in general. Let me talk about back testing just a little bit. Back testing is it's okay, but it's not the favorite area of the SEC. They're not really that big on it. I think that unlike model performance, back testing performance talk, it's hypothetical, and it's based upon a retroactive application of a strategy to certain data points, and it requires a lot of scrutiny. We like to think that It'll only be presented to very sophisticated, meaning non-retail clients. And we know from reading various no-action letters in this area that the SEC has looked at the failure to disclose the following kind of things in connection with backtesting. The failure to disclose that backtested performance was derived from retroactive application of a model developed with the benefit of hindsight, the inherent limitations of data derived from retroactive application, and whether the trading strategies that are retroactively applied were available during that prior period. Whether the advertised performance reflects the deduction of fees, whether all material facts relevant to any comparison has been disclosed, and the potential for loss. So there's a lot there on the back testing side. I think that in addition to, once you clear the hurdles, depending on your performance advertising, kind of how you're doing it, model, actual, hypothetical backtesting, portability, so on, there are just some related issues, of course, that follow on. One of which is just record keeping. I think given the SEC and FINRA enforcement initiatives on sales practices and suitability, and if performance advertising is part of the underlying transaction or methodology that's being reviewed, then you want to make sure all your I's are dotted and T's are crossed. So we're really coming back to to compliance again generally. The record keeping rule of the Advisors Act covers lots of different territories. There's a particular section, 204-2A16, that particularly deals with performance advertising. But we want to make sure that all the account statements reflect, the debits and credits and other transactions for the period of that statement. All the worksheets are maintained, that they're prepared contemporaneously. We have a general 5-year retention period, but we also want to make sure that the entire period of performance is recorded. So if you're looking at performance over a 10-year period, you want to make sure you have all the underlying data for that 10-year period. You can't rely on the other shorter, more general record-keeping rules. I think that in terms of just generally speaking, policies and procedures, again, compliance policies and procedures, the SEC, FINRA, the Department of Labor, they're going to want to know if your communications with clients are in fact congruent with the compliance policies and procedures that you should have adopted. So we know that some of the things that they like about advertising policy that they're looking for, they're looking for a multi-level process that involves, the performance group, investment personnel, and marketing to review all the advertisements. We know they like to see maybe monthly or quarterly reports that compare all the composites to the benchmarks, and some sort of true-up or process to deal with discrepancies. Clearly want to see managed accounts reviewed at least quarterly to ensure proper composite construction and maintenance. Maybe sometimes also the use of a second independent pricing service to verify the prices supplied by the primary service in case there's any discrepancies. What's happening recently in terms of priority? Well, we know that obviously, just being in compliance with GIPS standards is really important. People are looking for that. There's enforcement activity in that area. We know in the private fund world, the SEC is very focused on the potential for puffery or misleading alpha-type returns in the hedge fund world. We know it's a priority in terms of risk-based exams, and they've taken action on misrepresentation of performance and sales practices, inflated performance results, and what have you. The most recent example I can think of, and there were many, involved just last month, the SEC entered into a settlement agreement in Massachusetts with F Squared. They had charged the firm's co-founder and CEO with making false and misleading statements to investors. it was pretty, and they're, by the way, I don't mean to single out F squared in mentioning, in using them as an example. It just is that, just an example. They said that they advertised a 7-year track record based on actual performance, and the reality that the algorithm, sorry, that they were relying on as part of their investment methodology wasn't even in existence during the whole year. So that was an area where I think it's a good case to read. I can send anyone that's interested the settlement agreement for that, because it kind of really outlines a lot of the pros and cons and how-tos of performance advertising. I think even though we started late, I think we're close to our 30 minutes. So we ran through some general concepts about advertising as to set the frame. We talked about some of the particulars of performance advertising. We're seeing this in the marketplace with portability. We're seeing retail-level advisors exercising more discretion as a way of gathering assets, and therefore they're wanting to maybe talk about the performance of their portfolios they're putting together. We're seeing on the collective investment side, advisors want to exercise bragging rights about their activity in their collective investment vehicles. So it's an area that it's a good time to probably review your procedures in terms of how you go about doing it, or if you're thinking about doing it going forward, to make sure that you have all the communications in place, starting with the advertising. So thank you very much for your time today. Our next webinar is going to be in February, and I'm going to cover 2 things. I'm going to talk about I'm going to give a little bit of a heads up on cybersecurity and data breach prevention, only because they're very topical right now. And I'll be telling you kind of where to look and how to find the appropriate SEC and FINRA guidance, which is still embryonic and evolving. Now, we at the Wagner Law Group are not technology consultants. We're not going to tell you what kind of software to load or how many servers to keep. But I think in terms of what kind of policies and procedures you should have internally, we can guide you in that regard. It's definitely a hot topic. I'm also going to talk a little bit about some of the broader retirement issues beyond pure ERISA prohibited transactions that the SEC and FINRA are looking at in terms of sales practices, IRA rollovers, disclosures, fee grids, kind of from the broader perspective of the securities laws as they apply to the retirement world as compared to the pure ERISA analysis. So thank you very much for joining today. Make sure you email me any questions you have, and I will respond as best we can. And have a great day. Thank you.